Good afternoon, everyone, and welcome to today's webinar on protecting your bottom line, combating invoice fraud. That's topic number one. And topic number two is navigating the Contractors Debts Act. My name's David Crease. I'm a partner in Bardia Perry's commercial disputes team and also our building and construction team. Now, just before we get underway, a little bit of housekeeping. So please send through questions on the chat function. We'll endeavour to answer those at the end of the presentation. If we can't get to them, then we'll answer them by email. Also, you'll receive a copy of the slides, and the recording. It's being recorded, so you'll get that post-event so that you can look back on it if you so choose. We'd also appreciate if you'd give us some feedback. The short 1-minute survey, that will be emailed to you. First, though, before we hop into the presentation, I will do an acknowledgement of country. And I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land from which I am sending this webinar. I pay my respects to their elders, past and present, and recognise their continuing connection to our land, waters and culture. I extend my respects to the Aboriginal and Torres Strait Islander peoples who may be here online today. So, the first topic, as I mentioned, is combating invoice fraud. So we'll look at court decisions and what they mean and what their implications are, and then we'll talk about the what you can do, proactive strategies, the operational impact, and the practical steps that you can take to prevent being the victim of fraud. What is invoice fraud? I think it's probably fairly familiar to you. It's where a fraudster, a criminal pretends to be a legitimate supplier and who uses that impersonation to take money from the purchaser. So the usual method is to hack into the supplier's email account, impersonate the supplier, tell the buyer that there's a new bank account or something similar, and redirect the payment from the unsuspecting buyer to that fraudulent account. Now, particularly a risk for businesses that handle a lot of supplier payments, where there's a lot of purchasing going on, and are becoming prime targets for invoice fraud, both in terms of steps from the fraud. So, just before we get to the court decisions, just so you know, I think last year the ACCC published figures that this type of invoice fraud amounted to $154 million of lost funds. So it is certainly something of which we need to be well aware, and we need to take steps. So what's happened in the courts? And the usual question that arises is, well, who bears the loss? Is it the seller who's been impersonated by the criminal, or is it the buyer who has paid the money over? And in what, as far as I'm aware, are the only two reported decisions in Australia. There are some overseas, but they're all Australian cases. It was the buyer who came off second best in both instances. So the first case was Factory Direct Fencing and Kong AH International. That was back in 2013, which you may think may have been an contender for this type of fraud. Nonetheless, it was, if you like, your typical situation. Factory Direct supplied imported fencing products. Kong AH manufactured fencing products in China. What happened was that the fraudster impersonating Factory Direct impersonating Factory Direct emailed impersonating the supplier, emailed Factory Direct and said, there's a new bank account, you need to pay the money into the new bank account. Now, what had apparently happened was the supplier, Kong, had sent an email intended to go to Factory Direct. It had actually gone to the fraudster somehow, and that was how the fraudster got the details of Factory Direct. So the Factory Direct paid the money to the fraudster. Kong AH said, well, we haven't been paid, we need to be paid. Factory Direct said, well, I have already paid, I'm not paying twice. And by the way, you've breached the duty of care that you owe to me, to exercise reasonable care not to misdirect your emails that are intended for me, because then I am exposed to the possibility of paying money to a fraudulent account. Notwithstanding that it had been a positive act on the part of the supplier, Kong, which had led to the fraudster being able to get into the system, as it were, the court held that there was no duty of care based on the fact that it didn't really understand and wasn't explained to the court, or the court wasn't convinced how the seller could protect the buyer. The court thought that the buyer wasn't the most vulnerable, and in particular, the court pointed out that any vulnerability that the buyer had could be easily cured by telephoning the supplier and making sure that the bank details it had received were genuine. It didn't make any call whatsoever, it just paid, and the court ruled that in that case there was no duty of care owed by the seller to the buyer. Therefore, the buyer still owed the money, and judgment was given against the buyer in favour of the seller. We then move on to 2024 to Mobius Group and Initech. Now, in this case, Mobius was an electrical engineering consultancy. It was retained by Initech to do some work on a Rio Tinto project in Western Australia. Mobius Group had invoiced Initech for its consultancy fees, a not insignificant amount of $245,000. That $245,000 was overdue. A reminder was sent by Mobius to Initech, and that was somehow intercepted by the fraudster. It seems to have been some connection with the QuickBooks accounting system that the Mobius Group was using. Of course, the court report doesn't go into detail. In any event, this wasn't like Factory Direct, where Mobius had sent an email to an incorrect address. It had gone to or would have gone to the right address, but it was intercepted by the fraudster, who then emailed Initech supposedly new bank details, and Initech paid against those new bank details into the fraudster's account. And Mobius then said, well, hang on, I haven't been paid, I need to be paid. The responsibility lies with you. So you, unfortunately, have to pay me twice. Initech refused, and they ended up in the district court in Western Australia. Now, in its defence, Initech said essentially two things. Firstly, that Mobius hadn't used best practice to protect the integrity of its email account, and it got an expert to give evidence about what best practice was. And secondly, it said that, well, actually, unlike the factory direct case, we did call to verify the bank account, but unfortunately, and this is what the evidence was, the phone connection was not comprehensible, whatever that means. So they never actually got, although they called, they weren't actually able to comprehend whatever the answer was at the other end, and they just went ahead and paid without making a second phone call. The court held, firstly, and I suppose no surprise, that making an incomprehensible phone call and not making a second phone call was inadequate. The Initech didn't take adequate steps to protect itself and cover over any vulnerability it may have had. And secondly, in relation to what Mobius should or shouldn't have done in terms of protecting the integrity of its email account, well, the court held that Initech didn't do enough to prove that in these particular circumstances, having regard, for example, to the size of Mobius Group, it was only a small consultancy, it wasn't a big player, that it would have been reasonable for Mobius Group to employ best practice as opposed to relying on the inbuilt protections in the systems that it had. So ultimately, the court held that, again, there was no duty of care owed by a seller to a buyer, Mobius to Initech, to take reasonable steps to avoid economic harm arising from unauthorised communications, and ruled in favour, gave judgment in favour of Mobius Group. It wasn't quite the 245 because the bank had managed to recover $45,000 of the payments. So Initech had judgment entered against it for close to $200,000. So clearly, the courts are saying that in these circumstances, it's the supplier that bears the risk, and very clearly, a business has to ensure that it is paying against the correct payment details, because the liability for fraud will rest with you, particularly where you've done nothing or nothing adequate to protect yourself. It is that they are the only two Australian decisions, and fairly clearly they put all the onus on the buyer. So, yes, the onus on the buyer. So, in those circumstances, what can you do to, as is the name of the webinar, protect your bottom line? What strategies can you employ to try and avoid this situation? Well, very clearly, strict verification processes in relation to banking details, because that's where most of these frauds arise and how they operate, is very important. So how do you implement strict verification details? Well, clearly you need to confirm the banking details and be alert to the fact that if suddenly and unexpectedly bank details change, that's a real red flag. So you need to have a system in place to make sure that you always check banking details. You should check them anyway, whether or not they've been changed. Follow up a known contact number. So don't just use the number in the email, because that may be fraudulent as well. maintain a record of trusted contact numbers and use those numbers. Use a multi-factor confirmation if you can. You also need to educate your staff, so train them to recognise common warning signings. As I said, typical signs are an urgent or a late change in details, strange supplier email addresses. So look at the actual email address and does it look as though it's the email address of the supplier, or does it look as though it's some random address that you wouldn't expect? Again, train your staff to implement those verification procedures. And if you think that there have been fraudulent instructions provided and followed, immediately stop all payments. So contact the bank straight away, inform your own staff straight away, contact the supplier straight away, because you may then at least be able to get the bank to recover some part of the funds. So those things are paramount in trying to combat invoice fraud. In terms of best payment practices, if you can, use secure communications channels. So there are various commercial operators who supply encrypted messaging and systems specifically aimed to make sure that your communication channels, in particular, understanding where your payments need to go, are secure. So if you can employ one of those methods, it's highly recommended that you do. The second thing you can do is in your contracts with the suppliers, include a clause in there that anticipates that fraud may occur and shifts the risk from you to the supplier. The only thing you need to be careful of is that with smaller suppliers, where they have an annual turnover presently of under $10 million, you have to avoid unfair contract terms. So contract terms that aren't necessary to protect your interests or are unfairly protect your interests. And if you're not sure about that, we can certainly give advice as to whether a contract term would be unfair or not, and whether there's been a sufficient opportunity given to the supplier to negotiate that term. Just to recap, very important, one, to be vigilant, and two, to take steps to avoid fraud, and three, do what you can to protect yourself, because on current authority, it will usually be the buyer that ends up wearing the consequences of the fraud. So moving on to our next topic, which is the Contractors Debts Act. So what is the Contractors Debts Act? The Contractors Debts Act is an act that applies to most contractors. It has been enacted in order to protect subcontractors. In fact, notwithstanding that it's called the Contractors Debts Act, it's there really to protect subcontractors. And what the Act does in summary is it gives the subcontractors the ability to recover unpaid debts directly from the principal, bypassing the contractor who has failed to pay. So in a typical situation where you have a principal who is contracting either for work to be done or for goods or materials to be supplied. They contract with the head contractor, and in order to provide a particular part of the work or part of the goods or materials to be supplied, that head contractor subcontracts that part of the contract out to a third party, the subcontractor. The third party's contractual relationship is with the head contractor. So when they provide the goods either to the head contractor or in some cases delivers them directly to the principal, they invoice the head contractor, and the head contractor is obliged to pay. But sometimes, either for cash flow reasons or there may be other reasons, the head contractor doesn't pay. Now, in those circumstances, what the Contractors Debts Act does is it means that the subcontractor can go directly to the principal and effectively say to the principal, look, I'm owed money by my head contractor. The head contractor hasn't paid, so I want you to pay me instead of paying the head contractor money that you might otherwise owe to the head contractor. So the principal's not ultimately out of pocket, but the subcontractor gets paid, and the head contractor is then left to deal with any fallout. Now, there are risks of the principal not complying with the Act, because effectively what it means is that if the principal receives a notice, and we'll look at the detail of that shortly, the principal receives a notice from a subcontractor and doesn't comply with it, then the principal can become liable to not only pay, and if it pays the head contractor, it might find itself in a situation where it has to double pay, where it pays the head contractor, but is then liable because of non-compliance to pay the subcontractor as well. There's also the risk of reputational damage, because if subcontractors who have gone through the legitimate process of serving a notice under the Contractors Debts Act aren't paid, if they're ignored, then a subcontractor in future may refuse to enter into a contract where the ultimate purchaser is that particular principal, and that can get out through the industry. So reputation is something that can also be damaged if you ignore or don't understand your obligations as a principal under the Contractors Debts Act. So let's look at it in a little bit more detail here. So we're going to look at what the process is, what the consequences are of non-compliance, and some practical steps as to how you can make sure that you do comply if you're in the position of a principal. So firstly, the process in some detail, where we'll look at the applicability and conditions for debt recovery, the steps for obtaining a debt certificate and serving a notice of claim, what's required in the notice of claim, and there's also sometimes a priority issue. So we'll look at all those things. So firstly, as I said at the outset, the Act applies whenever a subcontractor or a supplier remains unpaid by its head contractor, by the contractor, for work or materials that the contractor has contracted with the subcontractor to supply. Now, one condition for getting paid by, an important condition for getting paid by the principal is that you can't just go to a principal and ask for payment of work for work and materials you supplied unless they relate to what the principal has asked the head contractor to supply. So there has to be a direct relationship between what you're supplying or what the subcontractor is supplying and what the principal is ultimately paying for through its head contractor. So what are the steps that you need to take under the Act as a subcontractor? So as a subcontractor, you apply to the court for what's called a debt certificate, which is a formal document that is issued by the court, which confirms how much is owed. And usually you can only get a debt certificate if you can provide the court with an adjudication determination, if you've been through an adjudication under the Security of Payment Act in a construction scenario, or if you've obtained judgment from whichever court of jurisdiction, according to the amount that is being claimed, has delivered. Usually it'll be a default judgment, but it may not be a default judgment. But in any event, after proceedings have been commenced in the relevant court, if there's a judgment, you can then use that to get a debt certificate. Once you've got that debt certificate, you have to serve a notice called a notice of claim, which gives the principal notice that you have a debt certificate and that the principal must now pay you instead of the head contractor. And it is an assignment of the debt. So you can assign a debt through a deed or another contract, but this is a statutory assignment of the debt, which operates merely because you have obtained a debt certificate and you have served a notice of claim. Now, a notice of claim has various requirements which need to be followed strictly. So, what are the necessary requirements in a notice of claim? So, essential details, unsurprisingly, the name and address of the principal, which is the party that owes the money to the contractor, the name and address of the contractor, who should have been paying the subcontractor. There has to be a statement that there's been a failure to pay. You have to reference the relevant agreement. As I've said earlier, you need a copy of the debt certificate issued by the court. You need a statement that requires the principal to pay the amount specified, and it needs to be signed by or on behalf of the subcontractor. All of that is fairly understandable because, and it's very similar to what you would have in a notice of assignment of debt if you were doing it contractually. Now, if a valid notice of claim is received, then the principal is legally obliged to pay the debt directly to the unpaid person, to the party, the subcontractor who has served the notice of claim. Importantly, the principal only has to do that, though, if there is still money owing to the head contractor. So if the notice of claim comes too late, if the head contractor has already been paid, the principal doesn't have to pay twice. That is unfortunate for the subcontractor, but as they say, timing is everything. And that payment has to be made within 7 days of receipt of the notice of claim by the principal. The principal, who then, as you might imagine, could be the subject of an angry call from the head contractor saying, hang on, you haven't paid me, why haven't you paid me? Is then able to say to the head contractor that, well, I have a document called a discharge notice. So I have paid the subcontractor pursuant to a notice of claim that I received because you hadn't paid. And I have received a discharge notice from the subcontractor, and that discharge notice is sufficient to release the principal for any further obligation under the claim and from any obligation to pay the head contractor, because the debt has been assigned. from the head contractor to the principal, and the head contractor then has no recourse against the principal for payment of the amount that has been received by the subcontractor and is the subject of the discharge notice. Now, you may ask, well, what happens if the head contractor, probably suffering from cash flow problems, hasn't paid a number of its subcontractors, and a number of them have gone out there and got judgment or an adjudication determination in their favour, and have served these notices of claim on the principal? Well, the principal has to pay them in priority of receipt. So the order the notices of claim are received. So it doesn't matter, for example, that a particular subcontractor has obtained its debt certificate before a second subcontractor. If that second subcontractor manages to serve its notice of claim on the principal before the other one, then it's the order of priority is whoever has served that notice of claim first. It's not who got the debt certificate earlier in time, or who even got the judgment, the underlying judgment, earlier in time. It's all about when the notice of claim was received. However, there is a provision that if within the 7 days after receiving the first notice of claim, further notices of claim are received, then all those notices have to be treated equally, so paid proportionately if the principal owes the head contractor less than the total of all of those notices of claim. So there is some the possibility of some proportionate payments to the subcontractor. So the principal receives the notice of claim, but doesn't pay. What then happens? Well, this is a situation against which I would suggest you need to take precautions, because the principal becomes legally liable for that non-payment. Remember, it was an assignment of debt, a statutory assignment of debt. So the principal is then primarily liable for payment of that debt. And if it doesn't pay, then the subcontractor, the unpaid person, can commence proceedings to enforce the debt certificate against the principal, in which case the court can order the principal to pay the amount, again, directly to the subcontractor. And that doesn't matter. It doesn't matter that the principal has already paid the contractor, the head contractor, for some reason. In other words, the principal ends up paying twice and would have to take some action against the head contractor to recover the payment that's been made to the head contractor. So it leaves it all in the lap of the principal, which is a reason why it's very important to know this Act exists, and secondly, know how it works and the issues it raises in protecting your bottom line. So you may ask, well, does the principal have any defence? Well, yes, it does. It does. So the first and possibly the most important is that if there's a reason why the principal didn't have to pay the head contractor, then because, again, it's a statutory assignment of debt, that assignment carries with it whatever rights the head contractor would have had, whatever rights the principal would have had against the head contractor to refuse to pay the head contractor. So typically, if the material, shall we say, that has been supplied by the subcontractor initially to the head contractor and then to the principal is defective, then the principal would have a contractual right, as against the head contractor, to refuse to pay for defective materials. If the debt owing by the head contractor to the subcontractor is then assigned to the principal has that same defence. it can effectively say to the subcontractor, well, if this was the head contractor who was claiming payment from me, I would have a defence against that. I have the same defence against you. Similarly, if the work that the head contractor was paying if the work that the principal was paying the head contractor to do, but which was actually being carried out by the subcontractor, hadn't been completed properly or on time, then the principal would be able to refuse to pay the head contractor. That ability to refuse goes with the assignment of the debt, so that the principal can also refuse to pay the subcontractor because the work was incomplete or hadn't been done on time or hadn't been done properly. So that is the principal defence that is usually trotted out by a principal. A second defence is that the notice of claim, remember there are a number of essential matters that have to be included in the notice of claim, that the notice of claim is invalid because it doesn't include all the essential details. Now, if that's the case, then the notice of claim is invalid or defective, and the principal can say in defence to a claim brought by the subcontractor, well, I didn't receive a valid notice of claim under the Contractors Debts Act, therefore the statutory assignment was never effected. It never arose, it didn't happen, it wasn't effective, and so I wasn't under an obligation to pay, and therefore I don't have to pay now. The other, and of course what that means is you need to look carefully at the notice of claim and know what it requires and what it doesn't require. Another possible defence is if the notice itself has actually been misdirected. And this can arise where the head contractor, where the contractor that owes the money to the subcontractor is not actually in a contractual relationship with the principal. So in a real life example, I have recently given advice to a principal where the notice of claim that came to the principal identified the head contractor as an entity that wasn't actually the head contract entity. What it appears had happened was that the principal had issued a tender for particular work. The respondent to the tender, shall we call them head contractor operations, had responded to the tender, and a contract had been entered between the principal and head contractor operations. However, when the work under that head contract was being tendered out to subcontractors, the tendering party was head contractor A PUI Limited, not head contractor operations. So the contract that was entered into with subcontractors, or the contracts that were entered into with the subcontractors, were entered into by head contractor A and not by head contractor operations. So when the notice of claim came, it was a notice of claim by the subcontractor who had done the work and supplied the materials, but the work had been done and materials had been supplied pursuant to a contract with head contractor A, not with head contractor operations. Now, of course, the principal was contractually liable to pay for work done and materials supplied on the project to head contractor operations to whom the tender had been let and with whom the principal had contracted. It had no contractual obligation to pay head contractor A. So in those circumstances, not least because there wasn't any debt owing by the principal to head contractor A, that notice was misdirected and invalid, and the principal had no obligation to pay the subcontractor under the Act. So again, very important to look at the notice of claim carefully to make sure that it has been that you, as the principal, are the party that is liable to pay. Now, again, if you don't take the relevant steps, then and you don't pay a valid notice of claim, or if you pay on an invalid notice of claim, this can create issues for you. Not just the reputational risk with subcontractors, and if you're in an industry where the subcontractors tend to be there's a restricted pool of subcontractors, then you may find that subcontractors will refuse or be reluctant to contract on your jobs. But you also have your own operational disruption. If you have to pay funds to other contractor, or if you have to pay twice to your, because you paid to your head contractor and then you find you have to pay to the subcontractor as well, well, obviously that's taking funds out of your cash flow. If you don't pay the subcontractor may refuse to supply or keep working. That's going to disrupt your project timelines. And then, of course, there's the distraction to your business, because if you end up being in the subject of a claim by the subcontractor, then there's going to be legal costs involved and distraction from your normal business. So there are very good reasons to make sure that you're aware of the provisions of the Contractors Debts Act and how they work in practice and what you need to do in order to comply with them. So what practical steps can you take to make sure that you do comply? Now, in one way, or in some ways, this is not dissimilar to steps you can take to insulate yourself against invoice fraud. Good record keeping. You need to keep clear records of your contractual relationships, and it's important to know who the subcontractors working on a job are. Remember the example I gave you about there being a different head contractor to the contractor that had contracted with the subcontractors. That can only be picked up if you've got clear records of the contractual relationships. You need to monitor your payment obligations, because and when those payments are due. Remember the timing issue. If you receive a notice of claim and after you receive the notice of claim you've paid a contractor, your head contractor, then you may end up paying twice. On the other hand, if you've already paid your head contractor, you receive a notice of claim and you need to pay the notice of claim, well, again, you've paid twice. So important to monitor those payment obligations. Very important to respond to notices of claim. As I think I've shown, they aren't the least complicated legal process and the least complicated document that you might receive. So I would suggest that you get prompt legal advice when you receive one, unless your staff are very familiar and trained with trained on reacting to notices of claim and recognising them in the first place. So prompt response, again, a bit like your invoice fraud. If you think that there's an issue, you need to act quickly, stop payments. Here, you get a notice of claim, don't wait to deal with it. Remember, you've only got 7 days to pay or deal with it after receiving the notice of claim. So that's a very quick timeline. You can also you can also, in your contracts with the head contractor, put in place provisions that will protect you against the event that a head contractor says, well, hang on, my contract says you've got to pay me, you've paid the subcontractor. I don't care that you received a notice of claim. You're in breach of your your obligations to me as head contractor to pay me on time. Now, as the head contractor, as the principal, you would have a defence to that, because you would say, well, there's been, to the extent that that is a debt, there has been a statutory assignment of debt. But you don't want to be in a position where you have to raise that issue on an adjudication application or in response to proceedings that are taken by the head contractor, even misguidedly. You would better off be in a position where you can point to a clause in your contract which says, hang on, expressly says, if I have received a notice of claim, then I am obliged to pay it, and that is not a breach of my obligation to pay you, the head contractor. So protective contract clauses, and again, staff training, making sure that your staff, and particularly your procurement and finance teams, understand the Act's implications and what the proper response procedures are. So that is the end of the substantive, if you like, part of the presentation, protecting your bottom line in particular in relation to invoice fraud and the Contractors Debts Act.